Everyone, Joe Gentili from Soroff Gentili LLP. So, one of the scariest things that we deal with in immigration law are denials issued by consulates, and any denial is pretty unnerving, whether it comes from USCIS or from consulates. But consulate denials are even more unnerving, and the reason for that is the existence of this doctrine called consular non-reviewability. I really hate this doctrine. Basically, what it stands for is pretty much what it sounds like. That if a U.S. consulate makes a decision, even if that decision is wrong, it's mistaken, whatever, U.S. courts have basically said that they're not going to review the decisions issued by consulates. That what the consular officer is basically the final word. And that is super frustrating because consulars make mistakes all the time, just like other agencies in the US government. And by not having any judicial review of those mistakes, it really creates a scenario for abuses of power, lack of accountability, and it's just not fair. That situation doesn't create justice in any meaningful way. So, given that background, fortunately, there's some hope, even if this does happen. If this does happen, there's some hope created by this case that was decided by the Ninth Circuit Court of Appeals, which is the U.S. court that's just below the U.S. Supreme Court, and it covers a lot of the Western United States. The decision is called Munoz versus U.S. Department of State. And what that decision held is that, okay, we accept that there's this idea of consular non-reviewability. However, if a U.S. citizen's rights are implicated by the consular's decision, and if it implicates their right to liberty, let's say, then that U.S. citizen is entitled to due process, which means that the consular can't just do their usual, we'll send you a denial on a one-page form and just check a box and that's it. You're owed a more fulsome explanation than that, and the decision is now reviewable. So this is great, because at least for people that have a immediate U.S. relative that's a U.S. citizen, so a husband, a wife, a child, if there's a consular denial, there's an argument that denial impacts that close relative's constitutional rights to liberty to live with their family, and maybe consular non-reviewability can be attacked that way. While the decision doesn't address this, I also think there's a good argument that if a business is implicated, if there's a U.S. business that sponsors an employee and there's a denial, that perhaps the business can challenge the denial, saying that businesses have a constitutional right for freedom to conduct their business as how they want, as long as it's lawful, and therefore they're entitled to due process as well. So right now, this is the law of the land in a lot of the Western United States. I'm not aware of decisions on this point in the rest of the country, but that decision that exists in the Ninth Circuit provides a great roadmap for other districts and other circuit courts of appeals to rule the same way. So basically, this decision provides an avenue of attack, a glimmer of hope where previously none existed. So it's really a major development in immigration law, and a great one for immigrants and their families. So we've had some recent success using this argument in cases, and I'm hopeful we're going to have some more success in the near future. So this is an area, though, although I really don't like consular non-reviewability, this Munoz decision and some of the cases that I'm hoping are going to come after it, it's really opening the door for not everybody, but at least a lot of people. If they have a consular denial and it looks like it's wrong, there's an avenue to challenge it. So as always, I hope you enjoyed this video, and if you have any questions, please feel free to reach out, and I encourage you to subscribe. Thank you.